Hey guys, I hope you all are doing well. I still have, I don't want to say I still have the bug, it's just the lingering cough, congestion, all that kind of stuff. And I very much apologize for the last video. I was trying so hard to suppress the cough and trying to turn it off in time. I apologize for those of you who are triggered maybe by coughing and sniffling and clearing of the throat. I'm going to try really hard to, if I can, to edit it out. It's difficult, or just cut it off. I don't know, but hopefully this will be better than last time. At any rate, of course, the continuation of Sarah Boone. And these are some things that I'm bringing up that are in the docket, in the court, whatever you want to call it, online, that happened, like maybe that day of the hearing on the 19th or after some of these things, motions and all that kind of stuff. But here's something interesting that I found that was, well, it was written on August 27th, but it was filed on September 18th, which would have been just a day before the hearing, and it was like 3:17 p.m. So the judge probably hasn't had a chance to read it, but this is a letter. At the end, I think it says a concerned U.S. citizen. So it's just somebody, some random person out there, I guess, who is pro Sarah Boone from Iowa. And the name is Liz Marie. I'll probably butcher the last name. But anyhow, I'm assuming she has written a letter of her concerns to the judge. So I thought it'd be interesting to see what this person has to say, even though by this time, at the time that this person had written it, Sarah had not gotten her new judge yet. So, but still, it's interesting to see what this person has to say. So it says, Dear Judge Kranick, I have been closely following developments in defendant Sarah Boone's case, who is accused of second-degree M, and I find her predicament very troubling. It is evident that Sarah Boone is a difficult inmate who, per your decision, has forfeited her right to counsel. It is an appropriate conclusion, for though the right to court-appointed counsel is constitutionally guaranteed, the defendant does not have a right to shop for one ad infinitum. Infinitum. I had to look it up to be sure, but I know that's kind of like that comes from like infinity, forever. So it's something like doing the same thing over and over again forever, which that's Sarah, all right. Anyhow, to do that until she finds the right fit. There are, however, some concerns and considerations which I fear will jeopardize the defendant's right to a fair trial, which perhaps have never been raised before. I don't know about all that, but let's see. We must first recognize, as you are personally well aware, that no person in the state of Florida, nor in any state of these United States, is allowed to legally perform the duties of an attorney without a legal law license, for which one has to pass a bar examination. That simple fact underscores the depth of education, experience, and savvy which are necessary for an individual to represent another individual or entity. But of course, these are 21st century considerations which take into account the complicated world in which we live today, in which we're not on any of the founding fathers' radars when the Constitution was first drafted. Expecting a layperson to be able to competently represent themselves in 2024 and with no accommodations would be tantamount to expecting a layperson to perform medical surgery. on themselves and without any access to modern tools. We would never allow such a thing under the law, let alone legally mandate that someone has forfeited their right to a doctor and must now perform surgery on themselves. This would be considered inhumane and a violation of human rights. As such, no individual without a law license should be allowed to represent themselves ever. As such, no individual without a law license should be allowed to represent themselves ever. Individuals who have the education and accreditation, although ill-advised, are a different matter. Well, I'm sorry y'all didn't get to see that. I apologize for that. Oops. Well, it got bigger. Well, but, they have the right to represent themselves. Look at Daryl and all these other people who, I think there are a few who did end up winning their cases, but it's a very rare thing. So, I don't know. I mean, it seems to be well written at least. But so she goes on to say, now considering that we cannot simply alter the Constitution without much due process, and with this I am not suggesting that Miss Boone be afforded yet another lawyer. What considerations should be taken in order to properly afford her access to a fair opportunity at self-defense? If another counsel is not an option, frankly speaking, there is no other choice but to allow the defendant to have access to any and all materials necessary to aid in her defense, including a law library, a computer, limited internet access, an investigator, etc. The defendant must be allowed a secured space and anything else that might reasonably need in order to research their case, study, defense, and properly represent themselves. These considerations should be provided for any defendant choosing their right to self-defense. This should not be seen as going above and beyond treatment of other pro se defendants. It would be seen as the treatment for all pro se defendants, for to deny these things is a clear violation of human rights. Okay. It has been argued by jailhouse counsel that none of those privileges are granted by the Constitution and that defendants should only have access to pen and paper, envelopes, and stamps. But I would venture to argue even further that the Constitution also doesn't guarantee a defendant the right to medical treatment, meals, or even personal hygiene supplies or clothing. It's just we the people have collectively decided that human rights and the dignity of the individual matter, and that they supersede any constitution or state charter, and thus it is for the betterment of all to honor them, for we might one day find ourselves at the mercy of the law and its enforcers. As long as the state is responsible for the care and housing of any inmate, pro se or not, we must also afford them a path to properly exercise their constitutional rights in 2024, not just in 1787. And then it is signed by Liz Marie, concerned U.S. citizen. Well, that was very nice of her to write on behalf of Sarah. But, like here, it has been argued by jailhouse counsel that none of those privileges are granted other than the pen, paper, and maybe stamps. But I think, as we all recall, they did give her a laptop. Maybe she didn't have exclusive access to the internet, but she had, Daryl didn't. I don't think he had anything more probably than pen and paper. And, but she got a lot of what she wanted, and she was offered a space of her own in which to work, but she didn't want to leave. I think something about her feeling claustrophobic and not wanting to be away from her friends. So it's like, it's not their fault, really, that she didn't want to do that. They're giving her options, but, I think they've pretty gone above and beyond. But at any rate, this is really after the fact, because now she has an attorney. But I feel like they gave her quite a bit, and they were, willing to, let her keep her documents in there and just to bag them up so there would be space for the other inmates. But I just thought that was an interesting thing to share. It'll be interesting to see when and if the judge responds to it. But I suppose he has other pressing things to attend to. But I thought that was worth the share. This is, and I know most of y'all have probably seen and heard, because I'm always, like I said, a little bit behind of the rest of the world, but the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome. It looks to me like the judge did respond to it, and in some ways it's going to be allowed, in other ways it isn't. But it was interesting. I thought, I used the word interesting a lot because things are interesting to me. What can I say? But they break it down more, and these are things we're going to remember from her very long interrogation, that I guess now the defense is saying, which it does look like they might have left out part of the Miranda reading. I don't think that's going to be a big problem from what I've been looking at. But these are things we're all going to remember from hearing the long interrogation with the two detectives. And of course, as we heard, it looks like now the defense is also talking about self-defense, using self-defense. I don't know if they're going to be able to use both or self-defense, but see, that one's going to be really hard because we know not a hand was laid on the other over and over again. It was not intentional. It was a good day. That's what I think is interesting. The things that they list. They're just going to say that, okay, so number one, it says the defendant filed an amended notice of intent to rely on the defense of battered spouse syndrome on September 15th, 2024. The defendant was provided discovery over 4 years ago. By the defendant's own admission, her expert, Dr. Julie Harper, saw her in 2020. The discovery in this case shows that the decedent and the defendant engaged in alcohol-infused spats of violence against one another periodically. And I think I remember him saying some of this, but there's some other things that he didn't say that are in here. I'm on number 5. This no more describes the criteria for battered spouse syndrome than a mental illness describes insanity under the McNaughton rule. 6. The conclusory statement that, in particular, the evidence will demonstrate factors that trigger BWS. The physical symptoms experienced during BWS, the distinct behavioral and psychological symptoms exhibited by the defendant that are consistent with a person who suffers from BWS, and the impact of BWS as it relates in the facts of this case, does not set forth the particular evidence that shows the defendant suffered from this syndrome. Number 7, the state's concerns that what the defendant is alleging does not meet the criteria for battered spouse syndrome is not premature. The discovery does not support a diagnosis of battered spouse syndrome, and the defendant has not alleged new facts to support battered spouse syndrome. Number 8, battered spouse syndrome is not actually a defense to a crime. It says the introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable, to show, in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent or great bodily harm. Of course, it quotes the little statutes and all that. Number 9. There is no evidence of a justifiable use of deadly force in this case, and the defendant has not alleged any such new evidence in her notice of her intent to rely on battered spouse syndrome evidence. 10. What the defendant told law enforcement was, A, when asked about the decedent's other injuries, in all honesty, we have not gotten into it. And then B, the defendant said that she and the decedent were having a good time on Sunday, having wine, painting, doing puzzles, and listening to music. Nobody laid a hand on nobody. And it's so short. And of course it says this, the page and this, the date of the statement. I have not touched him. We had a good day. It was a good day. We've had good days lately. D, there was no ill will between us last night. E, last argument was maybe last week. F, I was so happy, like it was such a good day. I kid you not. G, nobody touched nobody. Nobody touched nobody. H, it's the drinking. That's what it is. It's the drinking. I thought he was okay. J, no, I, everything was fine and dandy. J, the question was, why didn't you just let him out of the suitcase? To be honest with you, I don't know. Oh, I remember this one, K. I will never drink again. Like that's going to, save her from this. L, question is, what was your motivation for leaving him in the bag? Answer, I didn't have any motivation. It was me, he and I having a great day, fooling around and being stupid, and apparently me going upstairs and going, I'm guessing, I don't. I'm blaming it on the wine. M, question, you didn't lay hands on each other? Answer, no. No. Page 33, statement. N, I don't have any injuries. He and I have not been at it with one another. So O, it says, she didn't do this intentionally. Alcohol is a shitty thing. P, so it's like, okay, so while we're in a good place right now, I'm going to snap. Is that what while we were in a good place right now? And then Q. See, that's the thing too, but you can clearly tell that I had been drinking some. R. I didn't touch him, nor did he touch me. And then 11. The defendant's account is not one of self-defense, but rather an accident. And see, that falls into the self-defense and the battered spouse. And that's true. It's not like, usually people are going to have some more of a weapon, like, something that cuts or something that shoots, that kind of thing. And it wasn't like she just like snapped all of a sudden. It was like, but, and then it quotes some other case things. It says, but evidence that the defendant suffers from BSS is admissible in Florida to support a claim of self-defense when the defendant is charged with a crime against her abuser. Meaning that she was, I'm assuming, remember I was talking about, she would have to be fearful for her life. I don't think she seemed fearful. Now, I know she said things to the police, but I don't think she acted fearful at all. You're not going to put somebody in a suitcase and then just say, oh, I guess he'll probably get out and then go upstairs and not fear revenge for doing that, because I'd be pretty angry if somebody did that to me, honestly. So, yeah, I was up here. 11, BSS is not itself a legal defense, but evidence that the defendant suffers from BSS is admissible in Florida to support a claim of self-defense. And that's what Mr. Owens was talking about with Judge Cranick when he finally did say, yes, self-defense. When the defendant is charged with a crime against her abuser. If the defendant has changed her account, she is not alleged such in her amended notice of intent to rely on battered spouse syndrome evidence. Therefore, the state renews its request for the court to strike the defendant's amended notice of intent to rely on the defense of battered spouse syndrome. It does not set forth with particularity the evidence that would show the defendant meets the criteria. Additionally, the state renews its request to prevent any mention of BSS until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial. Defendant's argument is that the trial court thereby improperly required defendant to testify. We disagree. So I lost my place. Oh, there we go. We disagree. The trial court did not err in determining that no other testimony provided a predicate for that expert testimony. Thus far, the state is aware of no evidence supporting the defendant suffering from the syndrome, only evidence of alcohol-induced violence between both the decedent and defendant. Yeah, I can't argue with that. There is zero evidence that this was a justifiable use of deadly force. The defendant has stated the exact opposite, and she is the only one who can testify that it was a justifiable use of deadly force. So, yeah, those are, they're good arguments, but I think I might skip to where the judge is going to allow it in part. I think they're going to decide what I think what they said is they're going to decide at pretrial. They're going to probably argue that motion and see if they'll let them do that during the trial, is what I think. Okay, so here is Judge Cranick's response to the state for wanting it to be struck or stricken that the defense uses the battered spouse syndrome. But I'm just going to get down to here where it breaks it down. Says A, this matter is set, for trial on October 7th, 2024. On September 6th, defendant filed that certain notice of intent to rely on the defense of battered spouse syndrome, the notice. The notice provides a statement of particulars showing the nature of the defense battered woman syndrome as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, George Torres, and the name and address of a witness, Dr. Julie Harper. D, on September 6th, the state filed the motion. E, on September 13th, defendant filed the response. On September 15th, defendant filed that certain amended notice of intent to rely on the defense of BSS. Amended notice. G, the amended notice, among other things, provides the same statement of particulars showing the nature of the defense as the noticed BSS as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, George Torres, and the names and addresses of 6 witnesses. H, on September 19th, the state filed the amended motion. I, the court finds that both the notice and the amended notice comply with Florida R and all that other stuff. And then J, Medina versus state. And then it says, as relied on by the state, all address exclusion of admissibility of expert testimony on battered spouse syndrome at trial, not pretrial exclusion of expert testimony on battered spouse syndrome, and quoting all those things. Review granted. Address the introduction of battered spouse syndrome evidence, not the pretrial exclusion of the same. Okay, the letter K. The state relies heavily on Wagner versus state. And Wagner, according to appellant's testimony, as she bent down to pick up the keys with her left hand, the gun that she was holding in her right hand accidentally discharged, that she absolutely did not intentionally pull the trigger, and that she was not aiming at anything when the gun went off. The bullet discharged and struck the husband in the lower back. The trial court precluded appellant from presenting the battered spouse syndrome evidence at trial. At the hearing, no outright evidence of an accident was presented. See defendant's statements as outlined in something 10 of the amended notice. Okay, so orders and judges as followed. Number 1, the motion and admitted motion are granted in part and denied in part. 2, the motion and amended motion are granted in that defendant shall submit to an examination by an expert of the state's choosing. So there's the state gets to choose that. Said examination shall take place no later than September 26, 2024. So in other words, it looks to me like they're trying to get this all decided if they're going to use it or not before the actual trial, which that makes sense and seems fair to me. 3, the motion and amended motion are denied in that the notice and the amended notice shall not be stricken. 4, state's requests preclude defendant from mentioning battered spouse syndrome in her opening statement is denied. 5, state's request to prevent any mention of BSS until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial and admissible evidence of BSS is admitted into evidence at trial is denied. Okay. So I guess we're just going to see how that works out. Okay. And just going over now the motions, I think we already know most of these that the judge has responded to on behalf of the defense. It says, the court heard several of the defense motions. Motion for the statement of particulars, denied. I believe that was said in court, as stated on the record. Motions for additional discovery, denied. Motion to appoint forensic psychologist, granted, as stated on the record. The court appointed Dr. Brennan. Motion for costs, granted, as stated on the record. Motion to appoint crime scene reconstructionist death investigator, granted. Motion for the return of property, denied. Sarah ain't going to get her hands on that damn phone, but they'll be able to get the stuff from it. Motion for enlargement of time, granted in part, denied in part. Granted as it relates to filing objections to the state's evidence, denied as to remaining portions of the motion. So there's that. Okay, I thought I would pull up this Miranda right thing. And I'm so sorry, I'm so bad at introductions. If you are new to this channel, thank you for giving me a shot and welcome. As you can see, I'm very informal and strive to do better, but hopefully I'm still giving you the information that you need and want, I guess I can say. But since there's a thing about them leaving out the Miranda rights, I thought, let's look at this. Okay, it says, in Florida, Miranda rights are the constitutional rights of a suspect to remain silent. Well, see, already that's a problem because Sarah came in there ready to talk and all of that. But anyhow, I digress. Sorry about that. To remain silent and have an attorney present during questioning by police. These rights are typically explained to a suspect in the following way. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to attorney. If you can't afford an attorney, one will be provided to you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me? So I think what they did is they left out the last part. Do you understand the rights I've just read to you? With these rights in mind, do you wish to speak to me? But let's go jump over and just hear how they say it at the beginning of the interrogation.
I'm going to have you sit in the green chair at doesn't move. Appreciate you coming in.
Yes, ma'am. And I want to ask you about these whenever we have a moment.
Sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday. Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
All right. So you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect. Okay.
So, did she leave out something? I guess she did. But I don't know. I looked up a lot of things, and I don't think that's going to be a problem. But there is one point in here, she says it wasn't intentional, but I did remember that her attorney, Mr. Owens, brought up something about he comes for me. And she does slip that in, but I just don't know. I'm just going to play a little bit of this because I know we've already seen it like multiple times, but I still don't understand like self-defense. I don't know. Let's listen to the part where she says he comes for me.
So this morning we went to his autopsy, and we were informed of some injuries that he has by the doctor. So so he's got scratch marks to his back.
I know what that's from.
Okay. And it's called a contusion. Do you know what a contusion is? So like basically you're getting hit, and then you get a mark from it. You'll get bruising. Like someone hit you or something like that. It's called a contusion. So he had some injuries to his left shoulder. He had a cut near his lip. We could see his mouth was a little.
I haven't laid a hand on him.
Okay.
Also too, he fell off my son's bike.
Okay.
So I don't know, and he's notorious for running into the wall or the hall tree. So
Okay. What about the scratches? Because there's also sex.
Yes.
Okay. Because there's also like a scratch on like the back of his neck, like kind of like going, but it's like going straight across.
I have no idea what that's from.
And they're all recent. Like they occurred recently. It wasn't something that occurred post or that occurred a week ago or 2 days ago, 3 days ago. They definitely occurred, the night leading up to when he was.
In all honesty, we have not gotten into it.
Okay.
That's why, the only thing I thought you guys were going to ask me about, which I was going to be honest with you anyway, are the scratch marks on his back.
Mhm.
Everything else, I have no idea what it is. No idea what it is. Nonetheless, I've had my son over at the house too, so.
Well, your son was there when? When was he last there?
Oh gosh.
From my understanding, he was there last Tuesday.
I don't know if it was Tuesday, but yes, he was there last week. So.
Well, we're talking about Sunday.
Yeah.
We're just talking about what occurred Sunday. Because, like I said, the injuries they occurred within that time period.
So you're talking about day before yesterday?
Sunday leading into Monday. You called us yesterday at 1, but the incident, you guys were painting and stuff the night prior.
Correct.
So we're talking about Sunday, and then into
why
Monday.
I'm thoroughly confused, because we had a good time sitting on the back porch, having wine, and smoking a couple of cigarettes, and then decided to go inside and literally paint, do puzzles, and play, and listen to music. That's why nobody got out of sorts. This is what's mind-blowing to me. I have no clue. Nobody laid a hand on anybody.
He also had, on the left side of his forehead, he had basically bruising, and on his head and skull.
I have no idea.
As if something hit him.
I
considered
not
force
touched him.
trauma.
I have not touched him. I have not touched him.
Then how would you get those injuries?
Tell me and we'll both know. I have not touched him.
Yesterday, when we took photographs of your overall body, and they did the buccal swabs, did they go under your fingernails?
No.
Okay. Are you willing to let us
Absolutely.
swab underneath your fingernails?
Go for it.
Okay.
I have no idea, and I don't want to seem out of sorts, but I have no idea. We had a good day.
Mm-hmm.
It was a good day. We've had good days lately, even considering everything that's going on with our jobs and life in general and ex-wives and everything. It's been good.
See, that does not sound like self-defense to me. How many times does she say it wasn't intentional? Oh boy, sir.
I don't even know where this is coming from.
Yeah, you said the last physical was probably, you said, I think, a month ago? Where you got the injury, right? You said that was a month ago?
A few weeks, give or take, yeah.
A few weeks. That was the last, physical altercation between the two of you? You said a month ago he hit you with a curtain rod.
Yeah, with a curtain
Oh
rod. That's why I
my
can't
gosh.
believe you guys didn't take that either.
Wow.
We've been good. I don't know if, since the last time he got out of jail, like, we've been good, and he's been having his classes and seeing his probation officer, who's amazing. So.
What do you mean by good? What's your definition of good?
The probation officer?
No, you said you guys have been good. What's your definition?
I've been good. I don't think you all understand. He comes at me all the time.
So that's when she starts sounding defensive. But do you think using those words is going to help her? Let's see.
Comes at me. So it's either I flee or try to go upstairs and go to sleep. That's usually what it is. And I don't know if you talked to Brian about any of that. But
oh, Brian. Don't drag Brian.
Over there. So.
Right, but you're saying that you guys have been good, and when I asked you yesterday, the last incident that you could remember was the curtain rod incident, which you said was a month ago, so.
Give or take.
Right, so what do you mean by he comes after you? Like,
he gets belligerently drunk.
Mm-hmm.
Like, I don't know if you all have looked through my phone yet and seen any of the pictures and the videos that I have taken. And at one point, I started documenting everything.
Okay.
So you all will see in my pictures bloody fingers, split foreheads, he split my nose. I've got this.
Right.
I don't know if Brian told you about it, where I had to have I had one really bad surgery, but then it got really, 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 really bad, where I had to go like 4 or 5 more times afterwards for them to tend to it. And then poking me in the back of the leg.
Right.
So it's.
Then why are you still with him?
Everybody asks me that. When I tell you guys this, I really love him. Like I do. And I feel like I can help him. Like I feel like I could help him, which I did, because he came a really long way from where he was in Philadelphia to moving back to here and to dealing with everything else that he's been dealing with. I've really helped him. I bailed him out of jail, 3 times. I've gone to every single hearing and every single arraignment, everything.
Okay, we've heard enough. Yes, she did everything for him, and she takes responsibility for them having a good day. It's just going to be interesting. I mean, she does go back and forth, but most overall, she's saying it doesn't sound like self-defense. It doesn't sound like she was in fear for her life. And she'd have him arrested and then go right back and bail him out. So, I don't know how that's all going to work for them.
Going on a regular basis to the probation officer, and then to his substance abuse class and his, I don't know what VIP stands for, Matters Intervention Program. And actually listening to what it is everyone had to say, he changed. Like I could see a change in him.
He changed.
Before lashing out, he would think about it. And would always come home and show me his papers, and we would look over his papers together. Where it's like, wow, you actually are learning this in class? And some of the stuff that they would show them, like videos, he would come home and be like, Sarah, I'm so sorry for what I've done to you. Because for a video that he watches to make him feel that way, where it's like, oh man, I have done her wrong. But he's changed. He changed.
And that's why you're still with him, even though he's done all these things to you. And
when I tell you I love him, I love him.
Boone, when you love somebody, you have limits.
Everybody tells me that. All my neighbors don't tell me that. The office, property manager.
At some point, somebody gets enough, then they have to do something to defend themselves.
I would just flee, and I don't know if you would like to see it on my phone, or I think it's actually on a laptop. Because, and you have to understand too, I have, prior to classes in PO, kicked him out. How many times? I had him arrested. How many times?
But you also went down and bailed him out.
I know.
There you go. So I don't know. I guess some of this could be good. Some of it I don't think is going to be great. I guess again, just her lack of remorse. She she'll say, oh, I loved him and it was all a good day, but it was all because of her doing that he improved. So it doesn't make any sense to me how this is going to work for her. This is going to be a treat. No, not a treat. I don't mean that. I guess it is going to be kind of a treat in a way if justice is served. It's just that when Mr. Owens, I understand asking about her wearing street clothes, but when he asked for makeup and having her hair done, now I understand wanting to be nice and having a little makeup. I mean, look at Lori Vallow. I mean, everybody talks about, well, if Lori Vallow got it, so should Sarah, which is true. But I think you can get some of that stuff maybe there. But if you want a professional hairstylist to come in, I mean, this is court, Sarah, where you are accused of, whatting George. I feel like it just sounds like a glamour shots session. And what is somebody going to do differently with her hair other than brush it? Do you want a curling iron? I don't know. I understand a little bit of makeup. I get it. But he is going to have to file motions for all of that stuff, he said. I mean, I'm sure they'll let her wear the street clothes, but I think Mr. Owens had always also wanted her to wear them, I guess, at the two other things prior to that. Oh yeah, I guess jury selection and all that kind of stuff. And I get that. I can see where, that's what they did. They did give old Daryl that thing because they want to try to, they're wanting it, they are trying to make it fair to, from them looking like a regular person instead of an inmate. So I get that, but the hairstyling just really made me want to hurl. But you know what? Was it lawyer, Peter said? He said that he felt like that Mr. Owens felt a little sheepish asking for the makeup and the hairstyling. But as Peter said, you know what? A lot of people don't ask for that stuff, and Sarah has gotten some of the things she's asked for, so I guess perhaps in some weird, twisted way, we could learn from Sarah, Hey, what's the harm in asking, right? But that should be interesting. Okay, because I'm a little OCD and just a nerd about wanting to get things right, the only thing that I saw that she said, I guess if she said she read them verbatim, she did ask, which isn't on here, but I don't think there's any harm in that. Has anyone threatened you or anything like that to come in here? Well, no, I can already tell you right now, Sarah was not threatened. She wanted to come in. She had her list ready. She thought she was going to get her dang phone and go home. So she asked all of those things. It was like the last thing that she said, I think. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. And she said at no cost. Do you understand the rights I have just read to you? Okay. And I think the only thing that she left out, it wasn't exactly verbatim, but I think, she asked about the threatening. The only thing I did not hear her say was the second part of this. It's like, with these rights in mind, do you wish to speak to me? But I can't see where that's going to be a huge issue. But of course, I'm not a lawyer, attorney, psychologist, psychiatrist. Just somebody who's interested in law and crime and wants justice and is really nosy and curious. So, but we'll see how that all goes. Okay, so I was just going to go back to when I recorded Sarah's ex-husband, Brian Boone, and some of the things he said about as far as her being a mom to Lucas, even though that's not in question of this. I'm just saying that she kind of just checked out, it seems to me, like when Lucas was born and she wasn't very responsible. I guess I'm looking at Lucas just in my eyes as a victim, as is poor Brian, really. But let me just see if I can get it to the right place here.
Okay, so you technically have him more than she does. Is that where you're getting?
Yeah, that's why I said I was.
So even though that's how it's supposed to be, you still have him.
Yeah, it's not a good day. George is in a bad mood or whatever else reason. I think sometimes just she wants to stay up and drink and can't really do that. She's got to wake up and take him to school the next day.
Right.
Any number of different reasons. So.
Okay. How long have you known Sarah?
Yeah, see, so there you go. That's interesting. It's, she just, it sounds like her drinking, even though it seemed to me she had to like in the interrogation, that George, as we've already been through, I know, was the belligerent drunk. Not saying that he wasn't, but she's not trying to say that she was. You know what I'm saying? That's what makes it all a little bit fishy.
What can you tell me about her?
I don't. She's generally not. She can get a bit violent when she drinks. Not to this kind of extent. I don't know what happened exactly. But,
right. No, I'm just looking for.
But that was part of it. The alcohol has gotten worse and worse and worse with her over the years. That's one of the main reasons why I divorced her. I just couldn't deal with it. I mean, it got to the point where, on weekdays she'd go out, and I guess the George person is one of the people she had met. Because I separated at one point, went over to my parents' house to live for a few months. And I guess she met him over at the pool place or something like that. But I'd come back, and we were in therapy trying to work it out. And I mean, on a weeknight when he's got school the next day, I've got work the next day. I mean, she was out till 3 o'clock in the morning when the bar closes, and she'd bring people back over on the back porch. I mean, one time, some random person walked into my house and started screaming for Sarah at 3:30, 4 o'clock in the morning when we're trying to sleep. I mean, I just couldn't get over it.
So did you used to live here?
No. I bought her out of our house.
Okay.
I was going to just sell it and move because I kind of want to go back to College Park, which is where I'm from, but I thought it would be maybe easier for Lucas if I just bought her out and kept that house so he had a little bit of continuancy, kind of.
Understandable.
So that's what I ended up doing, and then she moved right down the street here, so. And
how long would you say the alcoholism has been a part of her life?
I mean, it's always been a part of her life. It seemed to have gotten worse and worse. I think more or less kind of since we had Lucas.
Yeah, see?
I think a lot of it was the fact that she kind of, I guess, maybe felt trapped or something.
Okay.
That,
felt trapped.
I mean, before that, whatever she wanted, you're outside having a drink, I want to go play pool, you go over across the street, you play pool for a little bit.
Yeah.
That's not happening anymore once you got a kid.
Right.
So.
How old's your son?
He is 9.
Poor Lucas.
So, but I mean, she started just getting really angry when she drank a lot. She said last night she fell asleep. There were plenty of times where she just basically passed out from drinking. So,
so you've witnessed her pass out from drinking?
Oh yeah.
Okay. And when she passes out, is she like out cold?
Oh, she's out.
Like, how difficult would it be to, like, wake her?
Well, I mean, if I were to, like, shake her or something,
right.
I could probably wake her up. But me making a phone call or noise probably wouldn't do it.
Okay. And would she be, like, in the middle of doing something and just, like, out cold? Or would she, go to bed and
it would
just be out cold?
Yeah, she wouldn't, like, fall over or anything. It would be more of a lay down and then she's just out.
Right. Okay. What do you know about her and George's relationship, if anything?
It was, I mean, I think she had him arrested like 5 or 6 times for domestic violence. I mean, he's stuck a steak knife in the back of her leg one time.
Okay. He's been arrested. So has he always been the one that gets arrested, or is she ever?
She was also one of the times.
Okay.
One of the times, both of them were arrested. But all the others have been him. But the very next day, she's in there trying to get him bailed out. So
There you go.
I don't know. Basically, they get drunk, they get in a fight, she gets upset, she calls the cops. I mean, granted, I saw lots of black eyes, bruises.
On her?
Oh, yeah. Yeah. So, I mean, there definitely was. You know,
Would you see George as much as you would see him or her?
I hardly ever saw him.
You hardly?
I honestly, I didn't like being around either one of them,
Right.
to be honest, and him more so. So, just I don't know. It's my ex-wife. She made me really mad with everything.
Well, I know that they were together before her and Brian were divorced, so that's probably one big reason.
Yeah, how the whole divorce went down, and just, I mean, the way she acted, and the way she changed, and the way they both are, I mean, what it's done to Lucas and everything else, he's nobody I cared to see. Let me put it that way. I mean, it's not like I really went out of my way to, like, it's just not.
When you guys do drop-offs or anything, is it always through the school, or would you like have to come here and see them, or no?
No, it's pretty much always during the school. Sometimes she would come over or something like that. Sometimes he would be driving, but I mean, he would just stay in the car, or she would come in. So I mean, I really wouldn't see him.
So it's not like you had like conversations with George. Okay.
No, I mean, maybe a few times when they've drunkenly called me at night because she was telling me she needed to escape because whatever's going on, or she's put him on the phone, but I don't know.
When's like the last incident that you recall of there being like a domestic dispute between her and George?
I mean, she told me like a week ago she had to escape from the house and wanted me to come pick her up. I told her I wasn't going to because I'm just tired of it happening. I mean, it was midnight. I mean, child's trying to sleep, and just honestly, I don't always believe her when she said these things were going on. And
she called you?
Yeah. Okay. Yeah, I mean, apparently she went back inside and slept well.
Mm-hmm.
Food the next day. I guess didn't really remember calling me, so I don't know if it was just she wanted to come over to. I don't know. She keeps on trying to come over to like hang out or something like that, or she'll come over to spend time with Lucas rather than actually just having him over here like she's supposed to. But she wants to come over there and play with him. So I'm not sure how real that was. Last time I know there was an actual physical confrontation. It's probably been a little while because this last time George got arrested, I know he was on pre-trial, whatever, something. I don't know. He had a parole officer. He had a domestic violence class. He's like.
So that's the last time. Basically, the last time he was arrested was the last physical altercation that you recall.
I think so.
Okay.
I don't know for sure, but I think so.
Can you have any idea what year or month that may have been?
Like a few months, maybe?
A few months ago?
Yeah, something like that, maybe. I don't think it was incredibly long.
Okay. Like around the holidays of last year, before the holidays?
I think it was probably before the holidays. I'm trying to remember.
Okay.
Because oddly enough, there was like a 3-week period where she actually had Lucas all the time she was supposed to because he was in jail for a month or something like that.
Okay.
Because they wouldn't let him out.
Yeah. And you said when she drinks that she can get physically aggressive.
She can. I mean, she did it to me a lot where she'd hit me and stuff like that. I mean, she's tiny. I mean,
What do you mean hit though? Like open hand smack you, or like try to punch you?
Yeah, she'd punch me. I mean, more arms. She many times would use her claws. I mean, I scratched my neck at times.
Scratches.
I mean, things like that where she'd dig with her claws. I never got that drunk, and I had restraint. I never touched her back. I think George didn't have that restraint, and at times he would hurt her back. So for all I know, all the times he got arrested, she started it. I don't know.
That's pretty interesting. For all I know. This is why I ask, why would he be a good witness for the defense? To me, it sounds like he would be a great witness for the state. I don't see how any of this is going to help her. What do you all think?
I wasn't there, so, but I know she could get violent at times.
Okay.
I mean, I don't know, it wasn't anything I don't know, too much. I mean, just.
Right, yeah, I mean, you don't feel like she was a huge threat, I'm assuming, right?
No.
Yeah, like you could handle yourself.
Yes.
Does she drink daily?
I think pretty much.
Okay. Do you know, like, her drink of choice?
That would be vodka.
Vodka.
Or wine, but vodka is the big one.
And does she or George have a job?
No.
Okay, one other thing I wanted to go over and listen to again was a video I posted, I think it's about 3 weeks ago. It was I think it was a combination of the interrogation of their neighbor and George's brother. And I was thinking about it, and now I'm remembering that. Remember, she said all the way through it was a good day, it was great. And from what I'm understanding, George had called his brother, this is George's younger brother, not to be confused with the one that's incarcerated. This is a different brother. I think this is George's younger brother. And so he received, according to this, a call on that night from 7:30. And it sounds like Sarah was already saying things in the background and all this kind of stuff. So I'm thinking that they were arguing then, as at least as early on as that, if not earlier. So her whole thing about it was a good day, I don't think that was accurate. So hopefully I've got this around to the right part.
And so it says you received an incoming call at 7:30, and you guys spoke for 4 minutes.
Yes. We was talking, I was playing dominoes with my kids and my wife. And at first I wasn't going to pick it up. Then I picked up.
Okay.
Because they were always fighting and stuff with the alcohol. So
Alcohol again.
he started talking to me, he was calm, so I was like, oh, okay. So I put it on speaker. So my kids are there, like, they're joking around with him, and he was joking around with them. And we're talking, and he's talking to me about when we was kids. And then, like, a couple minutes after that, that's when I hear in the back start arguing with him. No, I have to call my brother. I have to talk to him. And he's like, no, I'm talking to my brother. It was our phone, so. And then she starts arguing and telling him that, no, tell him what you've been doing to me. You choked me, this and that. But he was calm. And he was like, okay, I gotta let you go. And then he said, I love you. And then I told him I love you.
Yeah, see? So it sounds like she was already in a snit. So see, that doesn't add up with what she's saying. Tell her it's always like, poor thing, and nobody can ever talk. And just like what Brian was saying, and during his interrogation, that she's trying to put George on the phone. She wants to get everybody involved because it's all about Sarah. I don't know. Do y'all think, I don't know. That's a lot right there. And I have no idea why or how Brian could be of any help to Sarah. I'm looking forward to seeing how creative Mr. Owens is going to be. But I just thought I would bring those two things up. There might be other things. If y'all can think of anything else, put it down below in the comments. And I am still delayed on reading your comments from the last several videos. I wanted to get this out before my throat started acting all crazy and that kind of stuff. But I do always read them. It might be later rather than sooner, but I really do relish and enjoy reading them. So I thought I would share these few things with you, and I hope you'll have a wonderful rest of the day and evening. And as always, I love you. I really do appreciate you commenting, subscribing. If you haven't subscribed yet, please subscribe. It doesn't cost a thing. And sometimes I can be, interesting or at least provide interesting information the best that I can. I'm kind of limited, but hey, I like to try to dig, and I don't have a lot of resources like maybe some people do, but hey, I do with what I got. And yeah, just be sure to subscribe and like, because like I said, I'm trying to get to the big 3K. But okay, I love you guys. Thanks again as always. I really do appreciate each and every one of you all. Be nice to someone. Be nice to you. And I'll see you the next time.